It is a great victory for religious liberty, and the impact for religious liberty will have many ripples that I'll try to explain. But I don't think this is that significant with regard to the Affordable Care Act. There are other lawsuits, including one that the Pacific Legal Foundation is bringing to that could knock out a larger portion of the law that affect the larger decision. But today's decision is great for religious liberty because it says owners of for-profit businesses can exercise the same religious liberty rights that religious institutions and nonprofit corporations can, and they would be exempt from a contraceptive mandate that's against their morals.
And bottom line, when we talk about this regulation, now some people would say it's the law. No, this was a individual regulation. So that's what it doesn't go to the law, right? Is that what
that's correct. The law
okay.
just said that HHS could mandate what a certain minimum coverage was, and then through the bureaucracy, they determined that contraceptives are mandated for employers over 50 employees, but there were so many exemptions, and that was one of the factors that made Justice Alito for the court say that this wasn't essential to any government program to exempt for-profit corporations. But yes, the bureaucracy mandated that all 20 contraceptives, that including those that are abortion-inducing, have to be provided by employers of a certain size. And it doesn't matter what their religious convictions are. And as we know, the employers in the case at bar didn't even object to 16 of them, but they objected to those that induced abortion, and the government would not give up. But today, the Supreme Court said that they have to.
And that's one thing that is oftentimes missed. There's so much by the left on this that Hobby Lobby had 16 already. They were just saying, hey, look, we don't want to kill babies. And here we are with the information that we have and how it's being characterized. And one of the ways that it's been characterized and handled, if you will, is politically by the administration. Josh Earnest was asked about this. White House Press Secretary Josh Earnest, taking over for Jay Carney, was asked about this. And bottom line, the question to him was, the reporter asked, the court suggested in its ruling today that the Obama administration could expand an exemption on birth control coverage that you worked out with non-for-profit groups that have religious affiliations like hospitals and universities. Is that what you're talking about doing in this case? And here is Josh Earnest responding. Roll it.
No, what we're talking about doing is pressing Congress to actually take the step that's required to address this problem, to make sure that the women who work for these companies have access to the preventative coverage that they deserve, and that the Institute of Medicine, that's run by impartial, non-political scientists, believes that they should have access to. So that's what we're focused on, and we believe that this, because of the Supreme Court decision today, that Congress should act to address the concerns of the women who are affected by this decision.
Congress is divided as it is now. How likely is that to happen?
Well, we'll see. As we have with a range of other things, we'll consider whether or not there's an opportunity for the president to take some other action that could mitigate this problem as well. But again, we're still assessing the decision, so it's too early for me to state what kind of action would be available to the president, or what kind of action he would even consider at this point. But what is clear is that there is an opportunity for Congress to take the kinds of steps that would mitigate this problem, and we hope they will.
I'm just glad he's referencing the Article 1 powers outlined in Congress as opposed to just doing it himself. But Josh, Todd, pardon me, thought I was in the press conference there. Todd, this could be a ripple effect of the president attempting to take executive action as well. Is that something that we could see, especially after the behavior of this administration, when they don't like a Supreme Court decision, like Citizens United, we see some behavior from agencies that are, let's just say, legally suspect.
Well, I thought that response from the press secretary was amazing. What he's really suggesting is that Congress overruled the Religious Freedom Restoration Act because the decision today was based on an interpretation, a correct interpretation of the Religious Freedom Restoration Act that gives religious freedom rights to all sorts of people, including people who run a business for profit. The first response I heard from someone else from the administration is that they would follow the decision. So I hope they don't try through executive action to just ignore the ruling. But it is amazing to me that the decision was 5-4 and not 9-0. And it's further amazing to me that the administration would try to get Congress to overrule our religious freedom restoration rights under the Act.
Why do you think, I mean, what were the justifications for dissent here? Because, as you mentioned and you explained, it's pretty clear if we look at the law, if we look at the Act. So what are we looking for here?
I've read a lot of really overblown and incorrect and mistaken reactions about what today's ruling is, partially, I imagine, by people who are fundraising off of it. They're saying that women's reproductive rights are effective. There isn't a single woman whose reproductive right is effective. By the way, women own businesses, and women with religious liberty and men today won. But under today's ruling, possibly employees at certain will have an insurance company provide a separate plan. That's the exemption that was worked out with religious hospitals. The hospital wouldn't provide it, but the insurance company might have to. But for goodness sake, what we're talking about is the morning after pill.
Right.
If someone sometimes has to pay for their own abortifacient, I don't see how that limits anyone's, any woman's liberty. It may limit someone else's liberty. This is really a disingenuous response to today's decision that everyone should be celebrating.
Just a question, a little aside question. Was this just about the politics? Because it really plays beautifully for the left. You get a low information voter on an issue that concerns one of their identity groups, if you will, in identity politics, be it gender or race. We've seen this kind of thing, obviously, and both parties engage in elements of it, certainly. Left, I would argue, far more because they need to. Bottom line, this gets people talking about things that we really don't necessarily want to address. I have no problem talking about opposition to abortifacients, but we're going into an area of the contraception, of discussing that, and there's so much information there that's either not reported or not understood. Like, for example, Hobby Lobby said, yeah, we're providing 16. We just don't want to kill babies. You know, that's... So do you think this was designed for this purpose?
I don't know that the case was designed for this purpose.
Right,
why
the
the government
regulation
didn't confess error and give up is, maybe another, maybe a different administration should have done that. Whether that played a factor, I don't want to speculate, but I prefer to stay with the law. However, it's hard for me, even staying with the law, to say that there aren't some groups who always will take advantage of whatever case for whatever ideological and perhaps a partisan reason. We've got to expect that on both sides. I just think that it is quite a shame on something as emotional as this to not be truthful about what the ruling is. It is a victory for religious liberty, but it doesn't harm anyone else's liberty one iota.
There was another victory for liberty, the liberty not to be forced to join a union, a case coming out of Illinois. It's the Harris case. What exactly happened here?
Well, the Illinois had done something very strange. They said that if you were a personal care worker employed in someone's home to take care of them, and the person you were taking care of was the official employer, you were declared a state worker for union purposes and forced to pay dues, a fair share, so-called payment, even if you didn't want to join the union. Well, the Supreme Court today said that law that Illinois passed was unconstitutional as applied to those personal service workers. There was a larger debate about whether anyone should be forced to join a public employee union at all, but the court didn't go that far today. I was glad they criticized that application, because I think as a matter of constitutional law, no one should be forced to pay dues, particularly for a public employee union. But the court also was narrow today and reserved that for another day.
When we're talking about individual liberty, religious liberty, you can't really compartmentalize or divide those. They're one and the same. Are we seeing a new age where you referenced 5-4 decision on a pretty cut and dry black and white issue when it comes to the Constitution? Has this been happening for a long time, and now we're seeing it more pronounced, or are we in a new age when it comes to interpreting the Constitution with this court?
Well, there were a lot of 5-4 decisions, particularly at the end of every term, but I'll tell you what's new. What's new is, I think last Thursday was the 12th decision where the Supreme Court struck down an Obama administration overreach 9-0. So last Thursday's decision was about the president's unconstitutional recess appointments.
Right.
And so it is strange that there are as many 9-0 decisions against this administration. The other thing that I think is a disturbing, worrisome trend is that the government is trying to control so many aspects of our life that we have to bring these kind of lawsuits. I think Hobby Lobby was such an obvious, the suit they brought, the claim that was such a virtuous claim or suit. It's a shame that so many aspects of our lives are being regulated. The fact that if you're a personal care worker at home in Illinois, that the government had to say you're in a union. We should have never had to sue. It'll be a happy day if the government restricts its power over our individual rights so that we don't have to sue as often.
And with the case, the Harris case, the latter case in Illinois, do you think there's groundwork, foundation for another challenge?
There are the bigger
Next
case
step.
that the court sort of hinted at and discussed. I don't know if the court's ready to 5 votes to rule on, is whether a real public employee, let's say a teacher, let's say a teacher is a public employee but doesn't want to be in the teachers union. Right now, in many states, they're still required to pay the union dues, and the union spends their money speaking against their interests. The court's opinion in Harris v. Quinn did suggest that in a future case, they might reconsider a 1977 ruling that upheld that kind of mandatory unionization, closed shop in the public employee sector. But if the court continues along the direction it's going, they might reconsider that. And that would make all public employee unions optional, and the unions would have to convince people to join rather than force them.
And then we can also talk about how they convince, but I digress. I know you don't speculate, and I love it. And I appreciate your analysis because you go right to the law and you go right to the Constitution and where things line up. And Todd Gaziano, it's been a pleasure. You are the Executive Director, Washington, D.C. Center, Senior Fellow in Constitutional Law for the Pacific Legal Foundation. Thank you. Really appreciate you taking the time, my friend.
Thank you so much.
Take care. Crane Durham's Nothing But Truth. So, the Tea Party, dead or alive? after the Mississippi election. We'll talk to Seton Motley about it. Yeah, Crane Durham's Nothing But Truth.